Hello, everyone. Welcome to this meeting of the Special Joint Committee on Medical Assistance in Dying. I would like to welcome the members of the committee and the witnesses, as well as any who are watching us on the web.
And I am the House of Commons Joint Chair of this committee. And I'm joined by the Honourable Jana Martin, the Senate's Joint Chair. Today we are continuing our examination of the statutory review of the provisions of the Criminal Code relating to medical assistance in dying and their application. Just a few administrative notes. I would like to remind members and witnesses to keep their microphones muted unless recognized by name by one of the joint chairs. A reminder that all comments should be addressed through the chair. When speaking, please speak slowly and clearly for the benefit of interpreters. Interpretation in this video conference will work like an in-person committee meeting. You have the choice at the bottom of your screen of either floor, English, or French. One small note before we get started, we are expecting bells at around 10 o'clock. Is there unanimous consent to continue for 20 minutes following the bells before adjourning? Agreed. I see unanimous consent. Thank you. And Clerk will notify me when we're 19 minutes past the bells. With that, I would like to welcome our witnesses for Panel 1 who are here to discuss mature minors. As individuals, we have Elizabeth Sheehy, Professor Emerita of Law of the University of Ottawa. We are awaiting Dr. Edward Verhagen, who is a pediatrician and head of the Beatrix Children's Hospital. We expect him to be online shortly. And finally, Dr. Mary Ellen McDonald, an endowed chair in palliative care, all three by video conference. Thank you all for joining us this morning. We'll begin with opening remarks by Ms. Sheehy, followed by Dr. McDonald, and hopefully followed by Dr. Verhagen. You each will have 5 minutes, followed by questions. Ms. Sheehy, you have 5 minutes. The floor is yours.
Thank you, Mr. Chair. As mentioned, I'm Professor Emerita at the University of Ottawa, where I taught criminal law and procedure for 34 years. I'm also the sister of Matthew, who has developmental and some physical disabilities. I have firsthand experience with the extraordinary wait lists for supportive housing for people like my brother, and with medical professionals who repeatedly urged us to consider do not resuscitate orders when Matthew has required medical treatment. I add my voice to the clear and unequivocal opposition expressed unanimously by disability rights groups across this country to yet another extension of MAID. I testified before the Senate committee that studied Bill C-7 in 2020 to oppose extending MAID to people with disabilities who are not dying. We lost that fight, and so the bonfire started. The wood was laid and a match was lit. Our worst fears that people with disabilities would seek MAID not because their disabling conditions are intolerable, but rather because of our failure to provide the social and economic supports they need to lead dignified lives have come true. When this government then extended MAID to people suffering mental illness, it added accelerant to the bonfire. I wrote opinion pieces pointing out the discriminatory impacts on women, the fantasy that psychiatrists can distinguish between a mentally ill person who is suicidal and one who is expressing a rational wish to die, and the folly of accepting doctors' claims that they can determine that a person's mental suffering can never be alleviated. Now here we are about to toss children into the MAID bonfire, and this is what they are. They are de facto children unless and until some professional, not even the parent, decides they can be treated as adults for the purpose of deciding to die. The proposals of some organizations like Dying with Dignity are absolutely chilling. They appear to support a presumption that children of 12 years and older have the capacity to elect MAID. The position is impossible to square with how we otherwise treat children. 12-year-olds cannot consent to sexual contact. We see the consequences of sexual activity as so life-altering and so full of potential for exploitation that we brook no exceptions. We prohibit many other activities to children like consumption of alcohol or driving vehicles. We do this not only to preserve the life and well-being of children, but also to protect those who love them and other members of our community. how can we even consider allowing children to access government resources to end their own lives? The Maid bonfire will now spread to neighborhood trees, and no one's home or loved ones will be safe. What parent has not seen their teenager suffer deeply from anxiety, racism, misogyny, homophobia, depression, social exclusion? I know no one whose child has not struggled with at least one of these challenges. We live in a historical moment where the rates of mental illness experienced by children and youth have never been higher. We know too that intergenerational trauma and sexual abuse play a huge role in generating the mental suffering of young people, and that disabled girls and Indigenous kids are disproportionately at risk. It's morally wrong to abdicate our responsibility to address these traumas and respond to young people's distress with every resource we have. It's wrong to tell them that doctors and government will help them end their lives if they cannot see the light at the end of the tunnel. Our job is to give them that light, not help them snuff it out. My heart breaks for the parents and communities who've lost their teenagers to suicide. They and their families will never, ever be the same. And as we know, suicide among young people can spread like wildfire. We've seen this in Indigenous communities where each young person's death threatens every other sapling. And we see this phenomenon in other communities as well, where young people already struggling with alienation are devastated and demoralized by the deaths of their friends. The proposal to extend MAID to teenagers, regardless of their parents' wishes, is a huge betrayal to those whose kids have taken their own lives and to all communities fighting to keep their teenagers alive. We must put a firewall around the MAID bonfire to at least keep children and teenagers away. We know that young people's brains do not fully mature until their 20s, making it impossible for even mature youth to imagine either the possibility of a life of purpose and joy when they are stuck in the muck of alienation or adjustment to disability or their sexuality, or to comprehend the finality of death and the utter devastation their lost lives will wreak upon their families, friends, and communities. Extending MAID to mature minors is reckless. To trust that doctors can predict which young people cannot be healed or helped, or whether they have the maturity to make such irrevocable decisions, flies in the face of our not-so-distant eugenics past. To pass a law that require communities and parents do nothing when their young people throw themselves on the bonfire is to force us to watch our futures burn. Thank you.
Thank you, Ms. Sheehy. We'll now go to Dr. Mary Ellen McDonald for 5 minutes.
Good morning, and thank you, Mr. Chair. My contribution to this discussion is as a social science researcher with 2 decades of experience in palliative care research with both younger and older populations. Specific to mature minors, I was a member of the CCA expert panel working group for mature minors. I also supervised a philosophy student's master's thesis on the topic, published in the Journal of Medical Ethics in 2020. And my team has recently completed a qualitative study engaging youth in focus group discussions regarding this potential legislation with results that have been recently submitted for publication. What I want to focus on is how my research team has, following the CCA report, recently positioned itself to help advance the generation of empirical data to move these discussions forward. This position comes from a collective experience we had on the CCA expert panel, an experience of frustration that we were trying to advance policy and practice ideas without having ample evidence from youth themselves on the topic at hand. We continually circled back to the lack of research we could draw upon to help think forward about what MAID for mature minors could and should look like. On the CCA panel, clinicians could reflect on their personal experiences with members of relevant populations, and lawyers could think about some adjacent case law. But overall, it was clear that there was a very limited national or international evidence that captured the voices and experiences of young people themselves and their families regarding terminal illness, suffering, grief, and bereavement. Evidence was even more scarce on the views and experiences of young people who may be particularly vulnerabilized by the current state of practice, such as Indigenous youth, young people with disabilities, and those in the child welfare system. Now, as a researcher abiding by Tri-Council research ethics and community-based participatory guidelines, I take very seriously the ethical stance towards participants, not about them without them. It is not okay to be advancing research, policy, or practices on Made for Mature Minors without it actively soliciting and listening to youth voices. The United Nations Conventions on the Rights of the Child outlines how and why young people have rights to participate in matters that impact their lives and to express their views in any discussion that affects them based upon their own capacities. Given that young people remain ineligible for MAID, a form of end-of-life care that they may be interested in and may benefit from, it is reasonable to consider that their exclusion from conversations about MAID until this point have been in violation of the right to participate. In the spirit of addressing this gap, with two colleagues, Franco Carnevale and Sydney Campbell, we've put forward a proposal to Health Canada through the Healthcare Policy Contribution Program. We were solicited by Health Canada to develop this proposal. However, it is not yet finalized. The budget has not been approved, so I'm just going to stay at high-level details about its design. We have proposed a 3-year study that will meaningfully engage with young people to generate data with focus groups, interviews, and arts-based methods from which we can put forward evidence-based recommendations on the next steps pertaining to MAID for mature minors. We are starting with the premise that youth are agents with rights, and we are proposing to proactively work directly with young people and their caregivers to understand what is important to them regarding clinical and policy discussions around MAID specifically, and also how they want to be involved in palliative and end-of-life policy planning more broadly. We will spend the first year consulting with youth and caregivers about how the study should unfold. We have proposed including in our sample young people perceived as particularly vulnerabilized, such as youth with underlying health conditions like cancer, with mental health conditions, with disabilities, and with Indigenous young people. We propose to create a coast-to-coast-to-coast sample involving young people throughout, starting at age 12, and involve them from design through to analysis and dissemination. And together, our analysis will co-produce with the youth both a descriptive report on what is the state of the situation, as well as more theoretical and ethically focused analysis on what should be done and how should policy move forward. Thank you.
Thank you, Dr. McDonald. For our third panelist, there was a misunderstanding. That person thought they were in the second hour. Fortunately, somebody from the second hour is here in the first hour. So that would be Dr. Arundhati Dara, who is ready to speak, and she is a family physician. Dr. Dara, if you're ready, you have 5 minutes.
Hi, folks. That was unexpected. Thank you. Thank you to the Chair and to the members of the committee for the opportunity to speak today. I'm grateful to join you from Mi'kma'ki, the unceded territory of the Ulnu. I'm going to start with what I'm not. I'm not a lawyer. I'm not a bioethicist. I'm not a MAID scholar. I'm a generalist family doctor, and I have more than a decade in practice. I've also been a MAID provider since about 2017 as part of a full scope of palliative care work. I'm going to tell you today what it's like to provide MAID and what the consideration for MAID provision might be in minors were it to become legal. My first experience with MAID was with a dynamic, incredibly funny woman who had actually been deemed not to qualify under the legislation at the time. I represented her third opinion because she didn't have a foreseeable death and wasn't suffering sufficiently under the legislation at that time. She lived with constant chronic pain. It limited her life. She told me she was profoundly alone despite being very close to her family. She had plenty of joy, but she suffered nonetheless. I remember that she gave her glasses to her daughters. She told them to do something useful with them, and she closed her eyes and she made some very morbid jokes, and we all laughed. And then she went to sleep, and then she died. It was the most profoundly patient-centered moment of my career until that point. Why am I telling you that story? This woman was in her 90s. And the committee has actually asked me to think about MAID in mature minors. It's because the truth is that the considerations for her capacity for informed consent to that procedure are actually no different than they would be for a mature minor. Does she understand what's being offered? Does she understand the risks and benefits? Does she understand alternatives? A mature minor is someone who happens to be under the age of 18, but that age is mostly arbitrary. 18 is not a magic number. In fact, minors already exercise autonomy over their bodies in other instances, and we don't require them to explore every option to some external standard of satisfaction for every medical procedure. The capacity to consent is specific. As we move to expand MAID generally, there are a number of other considerations, including how we understand the developing brain, how we understand issues of mental health, soon to become an eligibility criteria. How that is or is not appropriately applied to minors would be an important consideration. And I don't feel qualified to really understand the developing brain well enough to say that. In jurisdictions where mature minors actually do access MAID, it's actually quite rare. They tend to have had very long histories with the healthcare decision making and with the healthcare system generally. That's the nature of illness in kids. In family practice, I have the distinct privilege to see kids grow over time, which is to say that I watch them cognitively develop. I'm pretty confident that I could figure out whether a patient of mine was able to consent. But even if I couldn't, MAID providers exist inside a community of practice, which gives us a network to lean on for resources and second and third and fourth opinions if we needed them. I want to close by naming the elephant in the room. There's a certain visceral revulsion to the idea that a child could suffer so much they request an assisted death. How is it possible that that does not represent a monumental failure of our medical system? Surely better palliative care services, better social services, all of those things would mitigate the need, the requests for MAID. It's okay to feel pain when a child suffers. We should. We would be monsters if we didn't. But the existence of better treatments, the existence of better services does not negate our obligation to have equitable and humane access to MAID if it is appropriate. Respectfully, I think here we are obligated to see past our revulsion. The right thing to do doesn't always feel good. In fact, a friend of mine who's an ethicist said, ethics only really comes into play when everything makes you really uncomfortable. We need to approach MAID and mature minors the same way we do in every patient. Each is unique and must be treated with careful consideration of their personal circumstances and the contexts of their lives. Thank you again for the opportunity to speak before you today.
Thank you, Dr. Dara. I will now turn it over to my co-chair, Senator Martin, for questions.
Thank you, and thank you to all of our witnesses for your testimony this morning. I'm going to begin the first round and call upon Mr. Cooper, who will have 5 minutes.
Thank you, Madam Chair. Thank you to the witnesses. I'm going to direct my questions to Professor Sheehy. We heard at our last hearing from a witness who noted that mature minors already make major medical decisions, including the decision to refuse life-sustaining treatment. That witness argued that it follows, therefore, that mature minors are as competent to make a decision with respect to MAID. Do you agree?
No, I don't agree. I think that there's a substantial difference between withholding or ceasing treatment and the active intervention of the state with its resources to end a life. I think that we know that actually this MAID is an exception to criminal code provisions that criminalize murder and assisted suicide. And so what we're talking about here is creating some sort of exemption from the criminal law for a specific category of young people. Currently, withholding life-saving treatment is not an individual decision. It is a decision that's litigated through a court process where there are witnesses, an adversary process, a judicial decision, an open court, reasons for decision. All of those are safeguards when it comes to the kind of decision that involves withdrawal of life-saving treatment. And so, this to move towards a regime of MAID for mature minors is a completely different exercise, and one that's deeply concerning when you're thinking about the fact that this is actually state intervention in ending a life.
Thank you for that. And it was further argued that mature minors understand what MAID is and have the capacity to deem their suffering to be intolerable, and was further argued that to not open and permit mature minors to make decisions around MAID, that such an exclusion would be discriminatory. Can you comment on those two things, that mature minors can understand what MAID is and their suffering, and therefore are competent to make such a decision, and the second point, that to exclude mature minors would be a policy that is discriminatory?
Well, first off, I'd say it's not discriminatory to exclude certain groups from MAID. We limit certain medical procedures to different age groups based on the risks. And for this group, a lack of understanding of their fulsome future horizons tied to the fact that their brains are still maturing tells us that the risks are real, and given the finality of death, that the risks are acute. I would also say that the group we're talking about, that I'm most concerned about, are young people with disabilities. And we know that children with disabilities are more affected by suicidal ideation. Young people with disabilities absorb the social message that their lives are not worth living. They feel anxiety about the burdens they place on their families. And it's not really until they mature that they can see that this is actually a social issue, the social discrimination against people with disabilities. And so I think that it's extremely dangerous to suggest that a young person, no matter how mature, can understand or predict their ability to accommodate life with disability and to find happiness in the future. I think it's actually deeply worrisome, to suggest that we will accept that person's hopelessness and give up on them and allow them to access state resources to end their lives at that point.
It was also noted that when it comes to medical decisions, that those decisions tend to be based on capacity rather than a firm age distinction. What do you say about that? I mean, why is it somewhat arbitrary to say at 18 you suddenly have the capacity to consent versus 17 and a half?
Sorry, I guess it depends on what you're talking about in terms of consent. If we're talking about medical treatments, the more serious the consequences of that medical treatment, the less likely it is that a court is going to say that the young person has the capacity. And so, you can't really talk about capacity without also talking about what's at stake in either accepting or refusing treatment or asking for the intervention of the state to assist in suicide. And so, the problem with a shifting age of capacity is, well, are we going to use courts to decide that? I think it's much more important to have a firm age limit so that we have a shared societal understanding of when and when not to allow access to MAID.
Thank you, Professor Sheehy. Next, we'll have Madame Briere for 5 minutes.
Madame Dr. Dara, I will direct my question to you, and I will ask it in French.
You've told us that you have 10 years of practice with MAD, and you've also said that there is no need to define a consent standard for each procedure. Or can you tell us, in your practice with the children that you've worked with, how many could have been qualified for MAID if that were possible for them? And should we not talk about maturity rather than age when we talk about consent?
Thank you. In my practice, so the nature of kids is that they bounce back. And generally speaking, when kids are ill, when they're really ill even, they get better. So the number of kids in my practice who have been so ill in a kind of life-limiting or life-ending way has actually been fairly small. Even in hospital, I can probably count on, two hands the number of kids that I've treated that I think, if MAID were available, would have been candidates in some way. That isn't to say that it shouldn't be available. A small sample size does not, in fact, make a piece of information or a policy decision not worth considering. I think, when you speak about maturity, I think that's exactly what we are talking about, is the capacity to understand, the capacity to think about what the consequences of a decision might be. And, to that point, I would say that, the understanding, the having a really robust understanding of what is being offered, what MAID is in fact a criteria for eligibility. So without that really clear voluntary understanding, MAID simply wouldn't be on the table. And I think that, I would argue that there are a lot of 90-year-olds that I've seen that have requested MAID that I've thought, actually, I don't think they really do understand. So I would say that, maturity even is potentially a difficult word. It's really about that specific procedure-specific capacity. Do you understand what I am offering you right now, this thing in this moment? In folks with dementia, there are often moments of lucidity where I think, yeah, they have great capacity, and then there are moments where they don't. It's time specific. It's incredibly specific. I hope that answers your question.
Oui, merci beaucoup.
Thank you very much. You've also mentioned that we should approach this issue of consent for mature minors as we do with other cases. You've discussed this already a bit in your answer. Do you think that the current eligibility criteria are sufficient for mature minors, or should we have further criteria for them?
I think that's, excuse me, I think that's something that, again, is really case specific. So there will be cases, I would argue, where it's pretty obvious that, a 17-and-a-half-year-old, to use an example given, would be, fully able to understand and consent and have capacity to consent to a MAID procedure. At the same time, there may be considerations of, minors who have mental health issues that overlay a life-limiting condition, and a number of different pieces where that capacity may be a little bit more difficult to sort out. And in those cases, I would say that the network of practice that I talked about before, where MAID providers don't kind of exist in a vacuum, where there are access to different resources, where there are access to different providers who can help shed some light on what's going on for an individual patient at an individual time, would be really helpful. I think I take issue from an equity standpoint with a blanket statement about age or condition or other sorts of things.
Merci.
I think it's really a complicated situation and incredibly person-specific.
Okay, thank you very much, Dr. Dara. Next, we have Monsieur Thériault for 5 minutes.
Thank you very much, Chair. Dr. Dara, given your experience and your testimony, if there are clinical situations where there could be a request for MAID. They are relative to an end-of-life situation. In other words, the process of dying is already started, is irreversible, and the patient is requesting this in an optimal palliative care situation. And even then, for example, in a case of serous sarcoma, relieving suffering is not possible. The limit of suffering is passed. In these kinds of cases, in the terminal phases of life, this is a time when we could look at this option. It's the different situation. We're not talking about somebody who's suicidal, who's 14 years old, and who's depressed. I don't think this is the case type of thing we're looking at.
I agree. I think you make an important distinction between sort of that, different types of conditions and different situations. I think the case that you describe, someone with, a cancer that is causing incredible pain and suffering, that makes a request for MAID, is a different case entirely than someone with a depression and suicidality. I think we have to be careful to conflate requests for MAID with suicidal ideation. They are not the same thing. Certainly in practice, they are certainly not the same thing. And up until now, at least, and I'm certain going forward, that is certainly something that we would ask around and explore with patients during any assessment. Is there an element of depression? Is there an element of sort of a mental health condition that is potentially amenable to treatment? So those are pieces that I think, conflating all of these things together, I think it muddies the waters, and I think, doesn't actually help us end up with an equitable process for folks to access what they need when they need it.
So once we validate, and we do in Quebec, starting with 14 years in Quebec, they can take this kind of important decision. Once we stress the importance of availability of MAID for mature minors. With regard to track 1, do you think this would be an acceptable option based on your experience? And this is the situation, generally speaking, where there are most the cases, even though generally speaking there aren't really that many cases. In fact, if I've understood your intervention, am I correct? This is what we should be looking at?
So in jurisdictions where mature minors can access MAID, it is actually quite rare. It's not a commonly requested procedure, and in the vast majority of cases, and I think I would say all, but I could not be certain, it is really around track 1, so that the process of dying has already started. There is a terminal life-ending disease process in place, and in those cases, we know that kids feel pain too. Kids suffer too. It is, as I say, viscerally heart-wrenching to see, but they suffer, and I think that would be a reasonable basis upon which a mature minor could request MAID.
Thank you very much, Mr. Thériault. Next, we have Mr. McGregor. You have the floor for 5 minutes.
Thank you very much, Madam Co-Chair. Professor Sheehy, I'd like to start with you, and I have taken note of your opposition to extending medical assistance in dying to mature minors, and I hope you understand that the questions I'm asking you are just coming out of a sense of curiosity as I'm trying to understand this subject matter. So my home province of British Columbia, we have the BC Infants Act. So that's a provincial law that does allow someone in the medical field to treat a minor as long as the minor has the necessary understanding to give consent to the treatment. So that is provincial law that protects someone in the medical profession. As long as they think that child has the understanding, they can go ahead with the treatment if they're under the age of 18. No specific age is required. It's just whether that understanding exists. So, if we had some medical conditions are incurable, some medical conditions cause intolerable suffering. And I'm thinking more of the physical ailments, which would be covered under Track 1 when we're quite sure that there is no coming back from this. So I'm just wondering, like if infants, if minors in British Columbia already have this ability protected under provincial law, and if there was ever a condition where, say, a 13, 14-year-old had a medical condition where it's quite obvious they are not going to be cured, they are not going to come back, and you can see they are in obvious state of physical suffering, why then must they wait until they are age 18? Why must they live 3-4 years in that kind of a condition when we already have this precedent under provincial law? I'm just trying to understand this.
Okay, first, in terms of BC legislation, I don't know every province's variations, but I do believe that treatment decisions are different, are treated differently in law than decisions that result in end of life. And for example, in the situation you mentioned, if a parent disagreed with the assessment that the person was mature enough to make the decision, or if a parent disagreed with the decision to end treatment, I believe this would be a litigated matter. And I believe the official guardian has to be involved when we're talking about end of life, treatments that result in end of life. So I don't think that MAID would be treated the same way under any province's legislation. I think it's substantially a different, it's not a medical treatment, it's actually, a treatment to end life. As for the question of, shouldn't we do this for those individual children who experience this kind of pain, I think that we have clearly an inability to distinguish between Track 1 and Track 2. I mean, once we allow further extensions to Track 1, we know for sure that these will extend to Track 2 and that we cannot contain it. For example, the Supreme Court in Carter said that its decision did not extend to mental illness, yet here we are. We've gone ahead and done exactly what the Supreme Court of Canada cautioned against.
Sorry to interrupt you, Professor Sheehy, because I only have a minute and a half left, and I do want to get one question to Dr. Dara, but thank you for your answer.
Okay.
Dr. Dara, I would like to know from you, because I know every province has a different variation of the law that allows for medical treatment of minors. I cited the law from my home province of BC, but can you explain to us, what does provincial law in your area require you to do as a physician in assessing that a minor has the necessary understanding to give consent to treatment? What are your requirements under provincial law to make that assessment, to arrive at a decision that you're comfortable with? I just want to have some understanding on that, please.
So in practice, it's exactly what I said in my initial answer. It's really it's an incredibly specific thing, and it's specific to the procedure or the treatment or the whatever that's being offered. And it can be as simple as, I think I need, like taking antibiotics for an infection versus, consenting to a surgical procedure or whatever. Like, it's really about, does this person understand what is being offered? Do they understand the risks and benefits? Do they understand the alternatives? In the case of you know, sometimes it's really obvious, right? Like a 6-year-old shows up and says, you know, whatever, like, I want to cut off my leg or something like that, something ridiculous, and without any good kind of understanding. It's fairly obvious, but in the case of a mature minor who's talking about a very serious condition, it's really about getting to the root of, does the person in front of you understand? In my practice, my long-term practice, I'm fortunate that, you know, I've watched a lot of these kids grow for many years now, and so I can say, you know, 5 years ago, I don't think this person could have, you know, shown up in the office and made a request for XYZ thing and really understood what they were talking about. But today, I think they can. And so I speak not as a specialist physician. I speak really as a generalist physician.
Thank you, Dr. Dara.
In community practice.
Thank you very much. Okay, and I will now turn this back to my co-chair to do questions from the senators.
Thank you, Senator Martin. Nous allons commencer avec la sénatrice.
We'll start with Senator Mégy. 3 minutes.
La sénatrice.
I see that Ms. Mégy is not with us.
Senator Kutcher for 3 minutes.
Thank you very much, Mr. Chair. Two questions to Dr. Dara. You reminded us of what in bioethics is known as the yuck factor. And just for our reminder, it's an intuitive emotional response to something should be interpreted as evidence for the intrinsically harmful or evil characteristic of that thing. And that's the idea that repugnance equals wisdom or repugnance equals a moral judgment. And that's been used throughout history to justify anti-Semitism, racism, homophobia, alternative sexuality, same-sex marriage, etc. Mr. Trump glorified it by his decision-making motto of, "This is my gut feeling, therefore it's right." Now, you warned us against making this mistake in our thinking. Do you think that this yuck factor and its counterpart, moral panic, may have characterized some of the highly emotional discussions that occur around MAID?
That's a difficult question because on the one hand, I think we do actually have to have very rational, evidence-based conversations with everybody with every perspective on an issue like this that is really of societal importance. And I will, refer here to Dr. McDonald's research around, really getting at the root of what you think about this issue. I think that's really critical. At the same time, I don't think we can, it is worth interrogating the yuck factor, as you put it. It's worth interrogating why we have that visceral feeling. Folks who would say that MAID ought not to be accessible to particular populations or in particular circumstances often point to, we need better services. That is always true. And to the extent that yuck factor kind of propels us to do better by our clients, our patients, our society in general, I think that that's a really good interrogative process. At the same time, we really do have to look beyond it, even if it's really uncomfortable. And I think this is a conversation that makes us all a little bit really uncomfortable.
Wise thought. In your clinical experience, what proportion of MAID deaths are what physicians, I'm a physician as well, would call good deaths? Peaceful, compassionate, family-supported deaths, a generally positive end to life. What proportion of MAID deaths would be within that kind of category?
A quick answer, please, Dr. Dara.
Sure. In my experience, every single one.
Thank you. Nous irons maintenant au sénateur.
We'll now go to Senator Dalphond, 3 minutes. Thank you very much, Dr. Garneau.
Insights and their perspective. I will focus on Dr. Marilyn McDonald because I think the discussions must be focused on data and not emotions and not ideological stance. So, Dr. McDonald, you refer to the fact that there is a shortage of empirical data to move forward the discussions. You said that we should accept the principles that the young people have the right to equality and the right to participate in the decision making that concerns their life. However, you would like to go along with the study from coast to coast to coast for the next 3 years. So do I assume from your answer that you consider that countries that have allowed so far mature minor to have access to MAIT don't have enough data to justify taking a position?
Thank you for that question. The final part of your question about international jurisdictions, I would say no, we don't have data from international jurisdictions that is completely amenable to a Canadian situation. I think there are a lot of specificities in Canada that require Canadian-specific data. One obvious one would be speaking with Indigenous communities. But the other answer I would give to that is even in the international jurisdictions, there's not much data either. So I don't think that we do have a bank of data that we can draw on and do a responsible job with the analysis.
I understand the project you have described is going forward, has been financed, and is going to move forward?
It has not been financed yet, no. We're still in discussions.
Oh, I see. So your discussions with Health Canada to get financing?
Correct. They invited us to submit the proposal, and so the discussions are continuing.
And what kind of budget are we talking about?
I don't really feel at liberty to address that question right yet.
Okay, but we're not talking of millions and millions. We're talking of
no, absolutely not. I'm a qualitative researcher, and so our budgets are generally quite small.
Okay, so and you think that within 3 years we could get all the informations that you propose to gather?
I believe so. I mean, we were very careful in the kind of the scientific design of the study. And I mean, as I say, we're starting with zero baseline. There's very, very little data. So any data would be useful, but we have tried to design a robust study that could be completed in 3 years that would give us a lot of information about different jurisdictions and different populations.
Thank you.
Merci, Sénateur.
Thank you, Senator. We will now go to Senator Martin. 3 minutes.
Yes, just continuing on with Dr. McDonald, as you say, you know, there is such a lack of data, and specifically a lack of Canada-specific data, which is very important. So, Dr. McDonald, I just want to ask whether you believe this data, this essential data, will be important for lawmakers, especially as we consider any expansion of MAIT for minors. How essential will this data be for us?
For me, from my professional opinion, it's so essential to have youth opinion and perspectives and experiences at the table as we're having these conversations. So I think it's absolutely essential. And by youth, I'm talking about individuals who are embedded in communities, embedded in families, and we would really, you know, in our design, we intend to see these individuals as embedded such so that we're having conversations with caregivers, parents as well to kind of get that whole context, and also with healthcare providers. So I think that's really important data moving forward.
Yes, and I absolutely agree with you. And as a parent, I think it would be very important to look at the response of parents and such individuals. Professor Sheehy, you noted you're concerned with that MAIT for mature minors could be abused regarding certain marginalized populations. Could you further elaborate on that point?
Well, I guess to elaborate, I would simply say that we know that mental health challenges are extremely high among children with disabilities, and that we also see those kinds of rates of struggle with respect to First Nations kids living off reserve. And so we know that these are the populations who will be most affected, and as well as kids living in poverty and isolation. So these are the kids that are going to be most vulnerable to trying to access MAID. And I'm deeply concerned about the discriminatory impacts. I guess the other aspect of this is our very limited availability of palliative care in Canada, particularly in rural areas. We know that only 15 to 30% of Canadians have access to palliative care. Palliative care is so much more important. And I think MAID, unfortunately, is the cheap and fast solution rather than investing the resources we should be investing in ensuring all Canadians who are dying have access to, good palliative care.
Thank you.
Thank you very much, Senator Martin. This brings our panel to a close. On behalf of the committee, I would like to thank Ms. Sheehy, Dr. McDonald, and Dr. Dara for their testimony this morning on a very, very important subject. We very much appreciate you being with us. And with that, we will adjourn temporarily as we set up for the second panel. Thank you. You'll resume a little bit early, but we need that extra time, so thank you very much. And with that, I would like to welcome the witnesses for our second panel. We have with us in the room Dr. Gail Beck, who is the Interim Chief of Staff and Clinical Director for Youth Psychiatry Program. We have Dr. Edward Verhagen with us, who is a pediatrician and head of the Beatrix Children's Hospital. by video conference. And we also have Mr. Neil Bélanger, Chief Executive Officer of the Indigenous Disability Canada organization, also with us by video. Thank you all for joining us. Our procedure is to give you each 5 minutes to make introductory remarks, and that will be followed by questions today. So with that, I'd like to offer Dr. Beck the opportunity to take the floor for 5 minutes.
Thank you. Good morning. Bonjour. Kwe. I'm Dr. Gail Beck. I am the interim psychiatrist-in-chief and chief of staff at the Royal Ottawa Healthcare Group, a psychiatric hospital based in Ottawa. I served on the expert panel on the state of knowledge of medical assistance in dying, specifically on the Mature Minors Working Group. My remarks this morning really reference that report, and I want to call attention to a couple of those, particularly in relation to capacity. And comment that the areas where clinicians struggle with patients and their families considering MAID for mature minors include development, both cognitive and psychosocial development. And one of the things in particular to highlight from the written remarks that you received is the fact that development of cognitive skills continues well into a person's 20s and mid-20s. And while this goes beyond the age of mature minors, it's important that clinicians keep this in mind. And as my hospital reopens its medical assistance in dying committee, we're keeping this very much in mind for all of our patients. We also, for us, culture is also a consideration. For any of us who manage the care of youth, it's always necessary to work closely with families, and we try very hard to be humble in consideration of a family's culture and of the family's influence on a young person with a serious illness, especially when that illness is irremediable and causing considerable suffering. Finally, family and other relationships are very important to youth. But independence in decision-making is something that many of them are coming to grips with. There's nothing that causes a young person to grow up more than suddenly having a chronic and especially a serious illness that can cause death. And so when we consider the assessment of these young people, we're very careful to make sure that we balance the considerations of their families as well as their own personal developing independence. In closing, I do want to thank you all for the opportunity to address this Special Joint Committee on Medical Assistance in Dying, and I would be happy to address any questions you have. Thank you.
Thank you, Dr. Beck. We'll now go to our second witness, Dr. Edward Verhagen. Dr. Verhagen, you have 5 minutes.
Thank you very much. I might be able to add a bit of knowledge from a country that has some experience in medical aided dying in mature minors. Myself, I'm also a professor in the pediatric palliative care. I'm one of the authors of what is called the Groningen Protocol for Newborn Euthanasia. As an important background, I'd like to share with you the situation in the Netherlands. We have a euthanasia law that starts at the age of 12, so 12-year-olds and older can ask for euthanasia. Parents' consent need to be present until 16 years of age, but if parents and children disagree on the request, we follow the child. So that is in the law. Then we've had 7 cases up till now of minors asking for euthanasia and whose request was really granted. Most of them, 6 out of 7, were 17. One was 16-year-old. They all suffered from end-stage cancer, untreatable, and they were suffering unbearably. That is one of the items that need to be fulfilled to get euthanasia. So it's infrequent. We have a population of 17 million people. It's infrequent, and 7 times in the last, I think, 15 years. All cases are reviewed and published, so they can all be accessed by everyone. Now, interesting development has also been the what we call neonatal euthanasia. We have a regulation, a legal regulation in the Netherlands that allows parents of newborns up till the age of 12 months of age to request for euthanasia if unbearable suffering is present. Both parents agree. There's some other requirements that need to be fulfilled. And then all cases must be reported and reviewed. And we've had, since the regulation came into place, 3 cases in around 15 years of neonatal euthanasia. All cases that were reported were reviewed and considered careful. So very infrequent, but it is legal, it is a possibility. And the most recent development is that we've just finished 2 years ago a 4-year-long study of how children die in the age group 1 to 12-year-olds. And this was qualitative research, and we've come across some parents who have reported terrible deaths of their child. Some of them had brain tumors, some of them had other diseases. These parents all ask for the possibility of euthanasia similar to neonatal euthanasia. And this request was forwarded to the Minister of Health, who decided that a regulation should be made as an extension of the Groningen Protocol to include 1 to 12-year-olds that were legally not capable of asking for formal euthanasia as written down in the law. Now, this regulation is now being designed. It's in the Ministry of Health at this stage, and at the end of this year, we'll hear how the final formulation has come up. So personally, I expect that in the course of 2023, the Netherlands will allow euthanasia in minors between 1 to 12-year-olds. Having said that, I am also convinced that the number of cases that we'll see will be as low as in newborns or even lower. But the main strength of the regulation is that we're talking differently to parents. We can provide and discuss all the options that are available, and they have a possibility to, if the suffering gets awful, ask for euthanasia. Practice has shown, both in children above 12 years of age and in newborns, that in practice this doesn't occur very frequently. Like 3 cases in 15 years is not much. So yes, there is a development going on in legalizing deliberate life ending in minors, and the biggest strength is that it allows a discussion about quality of life and quality of death that can currently not be held as it should.
Thank you, Dr. Verhagen. We'll now go to our third witness, Mr. Neil Bélanger. Mr. Bélanger, you have 5 minutes.
Thank you, committee members. My name is Neil Bélanger, and I'm a member of the Lac Seul clan in the House of Nigadane of the Gitxsan Nation. I'm also the Chief Executive Officer of Indigenous Disability Canada, and for the past 30 years, I've worked in a variety of roles, both in disability and health sectors. Before I continue, I'd just like to take this time to acknowledge the traditional territories and the peoples of the Songhees and Esquimalt nations, whose territories I work and live on and where I'm presenting from today. November 2022 marks the 8th anniversary of Indigenous Disability Awareness Month, an initiative created to celebrate Indigenous peoples with disabilities and the overwhelming contributions that they make to all of our communities. It is with irony today that while celebrations of Indigenous peoples with disabilities are happening across Canada, we meet here to discuss state-assisted death for Indigenous children under the MAID regime. The United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP, received royal assent in Canada in 2021. The declaration provides that member states must consult and cooperate with Indigenous peoples on certain matters, such as legislative or administrative measures that may affect them. This is in order to get their free, prior, and informed consent. Within the reports submitted by the expert panels regarding MAID for mature minors and MAID for mental illness, it has been verified that no tangible engagement or consultation with Indigenous peoples on MAID has yet to occur. Despite this reality and the overwhelming testimony of representatives from the Indigenous and disability communities against the expansion of MAID, as heard in previous sessions, to say nothing for the countless news stories, social media posts nationally and internationally expressing dire concern about the current state of medical assistance dying, the slippery slope of MAID remains unfettered. This begs the question as to why Canada, this committee, or anyone would presume the authority to make recommendations or implement actions for the expansion of state-assisted death and suicide for Indigenous children, Indigenous persons with disabilities, and Indigenous persons with mental illness as a sole condition, without first engaging those very people whom these proposed changes will target. This is difficult to understand and comprehend, particularly considering that Canada has exempted First Nations communities from the Accessible Canada Act until 2026 due to insufficient engagement with Indigenous communities, and further, to better understand the accessibility barriers facing Indigenous peoples with disabilities. Canada additionally states that this exemption reflects the Government of Canada's commitment to advance reconciliation with Indigenous peoples. The considered expansion of MAID to include mature minors' mental health as a sole condition and other proposed changes to MAID without comprehensive consultation with the Indigenous peoples of Canada flies in the face of reconciliation and is a further marginalization of Indigenous peoples and the continuation of the destructive colonial systems and their paternalistic mindset of trust us, we know what's best. The lack of any tangible consultation with Indigenous people of Canada should compel you as a committee to advise the government that in the spirit of true reconciliation, respect for the principles of UNDRIP, and to authentically honor and fulfill promises made to Indigenous peoples of Canada, that this committee's current work cannot continue, and that recommendations regarding the expansion of MAID cannot be made or endorsed. While I'm uncertain whether this committee would take such a step, I am certain that if the eligibility of state-assisted death is expanded to include mature minors at end of life, rather than providing adequately funded and comprehensive palliative care, this will result in the expansion of MAID to include mature minors not at end of life, who live with disabilities or have mental illness as a sole condition. This is not what might happen, this is fact. And this is the slippery slope of MAID and exactly the slippery slope we saw in the Truchon decision. We have heard recommendations from pro-MAID groups, pro-MAID expansion groups, and individuals that our children as young as 12 should be eligible for MAID, that we should be able to euthanize our babies born with disabilities anytime prior to their first birthday, and that persons with disabilities and those with mental illness as a sole condition, not at end of life, and whose mental illness and whose suffering is only due to lack of supports that we as a country could provide, but do not, should be eligible for MAID. As a country, Canada has the ability to provide adequate supports to ensure a good life for persons with disabilities and those with mental illness. We can provide adequate funding for and access to comprehensive palliative care for those at end of life and their families. MAID should never be seen as the solution to address the absence of those services and those resources, but it is fast becoming that, and this is the collective failure of us as the people of Canada. Thank you.
Thank you very much, Mr. Bélanger. I'll now turn it over to my co-chair, Senator Martin, for questions.
Thank you, and thank you to all the witnesses for your testimony this morning. For the first question from the CPC, we'll have Madame Vien for 3 minutes, followed by Mr. Cram for 2 minutes. So, Madame Vien, go ahead.
Merci beaucoup. Thank you very much, Chair. Thank you to the witnesses this morning. Mr. Dr. Verhagen, I hope I'm pronouncing your name correctly. I'd like you to give us some more detail on what you said concerning parental consent. I'm a bit confused about the need to have parental consent and when in this process, if there's a difference of opinion, when do you give priority to the minor's opinion? Maybe you could explain that a little bit more for us.
Yes, absolutely. Thank you for this question. So the Dutch health law says children and parents decide together in the age group 12 to 16. And the law also states that if the child and parents disagree in healthcare matters, doctors will follow the child. So this is not an opinion. This is what the health law says. And I must also add that in practice, this hardly ever occurs because in most cases that I know of, especially in end-of-life situations and palliative care, parents and children think alike and decide alike. But there have been cases in the past where, for instance, one parent would not allow withdrawal of treatments or intensification of treatments, where the child would want the contrary, and a second parent was somewhere in between. So those things sometimes happen, and we would follow the child.
Monsieur, Doctor.
Dr. Verhagen, could you, you said over the last 15 years there have been 7 cases. Can you tell us in total how many requests were made and how many were denied?
No, I cannot, because those were not registered.
Okay. Madame Vienne, 20 seconds.
Docteur, parlez-moi de la...
Can you tell us, in 20 seconds, I would have liked to talk about decisional capacity. That seems to be a deciding factor for going ahead or not. Perhaps another colleague will ask the same question. Thank you very much.
Merci beaucoup.
Je pense que mon temps est
Mr.
terminé.
Cram, you have 2 minutes.
Okay, thank you very much, Madam Co-Chair, and thank you to all the witnesses for being here today. Mr. Belanger, you certainly had some very powerful testimony, so I'd like to follow up with you. Can you think of any other federal
Monsieur le Président, je m'excuse aux collègues, son micro n'est pas allumé. Donc, merci.
Okay, let me just scooch over here then to the microphone. That does work. So, Mr. Belanger, can you think of any other federal government policies that affect Indigenous communities so significantly, yet had so little Indigenous consultation?
Well, I can't list them offhand, but I think that Canada has a history of implementing laws and legislations without proper consultation with Indigenous peoples. I think that's historically we've seen that, which is why that Canada implemented the UN Declaration on the Rights of Indigenous Peoples to compensate for that and to bring them in and to speak about it. We often see that Indigenous peoples and communities are consulted after the fact, and with that. With the mindset of, well, we'll fix what's wrong later. And this is no difference with MAID. And we were involved in meetings in the beginning where very few Indigenous organizations were at the table. And we had commitments from the government that comprehensive engagement would happen. And it never did. And it still hasn't to this day. So this seems to be kind of the rule that we follow when it comes to the Indigenous people. Hopefully it'll change in the future. And hopefully it'll change now with MAID.
And so is it your view that the federal government should undertake a fulsome consultation with Indigenous communities on the expansion of MAID before any expansion moves forward?
Without a doubt, as I said in my words, the Accessible Canada Act, which looks at accessibility within the federal side, within First Nations, has exempted First Nations till 2026 so that they can do proper consultation and hear their voices made and the significant impact it will have on our people and our communities. Why would it be not extended to the same priority? Why would it be pushed forward without proper consultation, without input, without their understanding? It makes no sense.
Thank you. Thank you, Mr. Cram. Next, we're going to have Monsieur Arsenault for 5 minutes.
Merci. Thank you very much, Chair. Thank you to our witnesses. My first question is for Ms. Beck. You said earlier that cognitive development of individuals continues beyond 20 years of age. And so that being said, with mature minors who want to have made, how can you be sure that they're sufficiently developed cognitively to ask for this procedure?
Thank you very much for your question. I'm just going to read a little bit from the notes that I give to residents in psychiatry and child psychiatry to consider when they're addressing capacity, because capacity is not magic. It doesn't happen at one age or another. It happens over a continuum. It's based on a number of factors. And when we consider decision-making capacity in terms of medical treatment decisions, we consider, first of all, whether the young person involved understands the relevant information about the condition and as well about about treatments and other measures that are being explained and provided. Secondly, we also consider the degree to which they appreciate the situation and the circumstances. And finally, we consider their ability to communicate the decision. So if I can use a really brief example, if you consider, for example, a young person who's, let's say they're about 10 years old, because this would be consistent with their developmental level, who's broken a bone, say their collarbone for the second time. That happens pretty regularly. Well, they've had a broken collarbone before. They go to the emergency room, and while they're in the emergency room, they sit like this. They sit like this because they've had that collarbone has broken before, and they know that if they sit like this, it relieves the pain of that broken collarbone. The pediatrician will come in, or the doctor will come in, and they'll say, "What are you here for today?" And the child will say, "I broke my collarbone. I broke it once before, and the doctor at the time said it might well happen again. And I know that if I hold my hand like this, that it won't hurt as badly." And the parent will listen. This isn't an uncommon thing. I work in a pediatric emergency room. And so the doctor will say, "We think you need an X-ray." And that this has happened to this individual before, and they say, "Yes, we need an X-ray." Now, I only use that particular example to explain that there can be a complexity of medical conditions. And clearly, when someone is considering, when a young person is considering something more complicated, like a mental health condition, or when they have a glioblastoma and they're facing making decisions about dying, and they're working with their parents around that, it's a much more complicated situation for the clinician. But clinicians in child and adolescent psychiatry are very experienced with dealing with capacity, and so.
Sorry, Mrs. Beck. I have so few seconds or a minute and a half. So if you can provide us in writing all this, I mean, the committee would appreciate. I'd like to turn now to Dr. Verhagen. Bienvenue au Canada.
Dr. Verhagen, welcome to Canada virtually, and this situation. In the social situation of the 7 cases that you said had gone to made medically assisted death, and here we say it's often the most vulnerable, the poorest, that ask for medically assisted death, whereas the statistics don't seem to show that. But up to now, it's more or less middle-class people who And so 80 or 90% have already had palliative care but have chosen to die. So the 7 cases in Netherlands that the 7 children, minors, what was their social situation?
The social situation wasn't described in detail so much, but generally I can say that they were all well insured. They were all from middle class or higher class families, and they purposely chose death, knowing about the suffering that they had gone through and having heard their prognosis and their certain death. And also both parents in all those situations agreed there was no conflict. And also from the medical point of view, there was full understanding and consensus that that suffering could not be ameliorated in another way. So there was no discussion there.
Thank you, and we'll move on to Monsieur Thériault for 5 minutes.
Mr. Thériault, 5 minutes. Thank you very much, Chair. I would like to speak or ask a question of Drs. Beck and Verhagen. First, Dr. Beck, you're no doubt aware of the expert committee on mental health, where we see that a good practice would be to have exhausted all available treatments and beyond a shadow of a doubt shown the progression of the disease. And when we talk about mature minors and a good medical practice is to have exhausted all available treatments, all the possibilities that we might have to cure an individual. So somewhere, mature minors, when we find them in this type of situation, it's because there's nothing more that can be done. And so we are usually in people who are in what we call track 1, where their death process has already started. And so in a continuum of palliative care, they can move on to requesting medically assisted death. And as a committee, if we make a recommendation to limit medically assisted death to mature minors in phase 1 or track 1, would that not be appropriate, in your opinion? And Dr. Beck, possibly, and then Dr. Verhagen.
Certainly in the case of mature minors, one of the questions that arose on the expert panel in terms of mental disorders very specifically was that as a child psychiatrist, and I've been in practice many years, we could not say that for a mental health disorder that you would reach the stage by the age of majority that all treatments had been tried, even specifically because some treatments that you would use to treat certain conditions would only be treatments that we would use once the person became older. So that answers, I think, a part of your question, but one I think that people will probably consider. And in terms of some of the other illnesses, the only place where my scope of practice really allows me to comment.
Alors, Dr. Verhagen.
Dr. Verhagen, would you like to say something?
Yes. So, from how I understand it, the track 1 sees to children or people that have a disease that they're dying from, and that would allow them, yes or no, for medical aid in dying. Our euthanasia law requires hopeless and unbearable suffering, which means that there is no good outcome possible, that there is a certainty of the diagnosis. And those 7 cases that I've described were all somatically ill children that were dying, and it was a shortening of the death process that they asked for and received. So I would say without a track 1 condition, it would be more difficult to envision a good regulation.
Merci.
Thank you. With regard to decision-making capacity, some practitioners tell us, and here it's Dr. Verhagen I'm asking the question of, some practitioners say when a patient, a mature minor, is ill, and there's kind of a synergy, a symbiosis with the family, and so the parents live this with the child, and if the child says, I want to move to medically assisted death, and it's rare for parents to say, no, we don't agree. And when the minor wants to go to the end of this process, it's rare for parents to be opposed. So when we talk about consent, consultation of parents is necessary, but consent is not necessary, I believe. Briefly, Doctor.
No, consent is not necessary. So we follow the child. We know that children and parents are often on the same page, but not always. Conflicts have been described frequently. And very importantly, the doctor will only go ahead in providing what is asked if he himself or she herself is convinced that this is in line with what is best, or what is the real and genuine opinion of the child. So if there is any doubt on the side of the doctor of whether or not he or she is listening to the child or maybe the parent's opinion, then he or she will not go ahead and provide it. So there need to be a firm conviction on the side of the doctor.
Thank you. And lastly, we'll have Mr. McGregor for 5 minutes.
Thank you, Madam Co-Chair, and thank you to our witnesses for appearing today. Mr. Belanger, I'd like to start with you, and I take your comments about the lack of consultation. I understand the Canadian government and provincial governments have a very sorry track record on that front. But, you know, this committee, this special joint committee, was entrusted to look at 5 major themes. Now, with mental disorder as a sole underlying condition, that has already been passed by the previous law. It's going to come into effect in March of next year. But on the other themes, like mature minors, the state of palliative care, protection of persons with disabilities, and advance requests, this committee is not only going to make recommendations on how law and policy might go forward, but we're also going to make recommendations on things like consultation with various groups, on funding gaps that may exist. I mean, I don't want to presuppose what kind of recommendations our report will have, but they might end up being quite varied. So I guess this is your opportunity, sir, to inform this committee the kind of recommendations you would like to see in our final report on how the federal government needs to step its game up on consultation, especially when it comes to Indigenous children who are living with disability. So very briefly, in about a minute, can you just inform us what kind of strong recommendations you'd like to see in our report on that theme?
I'm sorry, I don't know if it's my microphone or yours, but it's kind of cutting in and out. But the recommendations would be that I would make is to pause the expansion of MAID, making recommendations to consult Indigenous people after the fact, after the changes are in place. It doesn't make any sense. So we know historically there's underfunding. We know that there's lack of critical mental health services and the effects of poverty when we have 80% of First Nations in Canada living under the poverty line. So making recommendations to consult after you change the law are not good recommendations. Put a pause on it. Engage the people that you are making recommendations for, get their input, get their insight. So I mean, I can't make recommendations for the expansion of MAID to go forward when you haven't consulted the very people that these laws will be applied to. It would be impossible.
Yeah, no, that's very well taken. We've heard on we've been discussing, provincial laws that allow children below the age of 18 to consent to medical procedures if the medical professional is convinced that they have the capacity to understand the treatment and what it may mean. And some of these could be very serious medical interventions. And I take your point about the lack of supports that exist, and those have been very well documented. But if we were to arrive at a situation where a child has in fact had access to the full range of supports and is in a state of intolerable suffering with an incurable disease, I guess what's your understanding of a child's ability to give that kind of consent when that is already an established right under provincial law for medical interventions?
And I'm not as familiar probably as I should be with the Infant Act in BC, and I may be wrong in my interpretation, but I believe that mature minors under that can make certain decisions in their best interest for their medical. But I think that also the hospital can step in and challenge that, or the medical service can challenge that if they're refusing treatment that is for their benefit that will continue. I may be wrong, and I believe that's the same in Alberta from what I know. But I think what we're, these questions here about mature minors at end of life, look at track 1 only. We never look at the intersection of what that means for track 2. So now if we pass a law that allows mature minors at whatever age, we've heard as young as 12, we know that next it'll be track 2 for mature minors with disabilities, not at end of life, with mental illness. We know that that's the progression that will happen. So we can't discuss one without the other.
Okay, thank you, Mr. Boulanger. Sorry, I only have 30 seconds, and I just want to get a quick question into Dr. Verhagen. Just very quickly, sir, how has Dutch political polling been like on this issue? Like, what has society's reaction been to how the law has been implemented, the possible changes? We just wanted to see, compare that with what's going on here in Canada.
Yes, very briefly, Dr. Verhagen.
Okay, we've had the law since 2002, and there's hardly any discussion about its implementation. It helps that euthanasia in mature adults is so extremely rare.
Thank you. Thank you very much. And I'll now turn this back to my co-chair.
Thank you, Senator Martin. I regret to say we will only have time for one senator, and I will arbitrarily go to the first person on my list, Senator Kutcher, for 3 minutes.
Thank you very much, Mr. Chair. And Senator Delfon and I discussed this already, so I'm speaking on our behalf, joint behalf. Could I ask first, Chair, that we ask Dr. Verhagen to send us the study, the 4-year study that he referred to, please, so that we could have a chance to read that. 2 questions, one to Dr. Beck and then one to Dr. Verhagen. I'll read them out both, and then you could please respond. So, Dr. Beck, in your opinion, can properly trained clinicians conduct the necessary, thoughtful, and well-considered assessment, looking at all those factors you discussed, of capacity for mature minors in consideration of medical conditions, including potential MAID? And then the second for Dr. Verhagen, we've been told that if we allow MAID for mature minors, the floodgates will open and large numbers of young people will die as a result of MAID. In your experience, was that a similar sentiment that was common or talked about in your jurisdiction before the law was put into place? And then if that was the similar sentiment, what was the reality in terms of what that sentiment actually was?
So I can answer fairly quickly. For physicians in particular and clinical psychologists, as well as other practitioners, the assessment of capacity would be considered essential in their scope of practice, and they probably wouldn't have succeeded in their exams if they hadn't been able to assess capacity.
So that would be a yes then?
Yes.
Okay. Dr. Verhagen?
So the fear of a slippery slope was mentioned twice. First, when the euthanasia law was accepted in 2002, and it never became a reality. The numbers have never gone up. A second time was with neonatal euthanasia. Some people expected huge numbers of newborns being killed. It never happened. So instead of 3 cases every year before the legislation, we went down to 3 cases in 15 years, so no slippery slope there.
Thank you very much. With that, I'm afraid we'll have to conclude panel number 2. Thank you very much, Dr. Beck, for being here this morning. Thank you, Dr. Verhagen, for your testimony, and thank you, Mr. Bélanger, for your important testimony. We very much appreciate it. It will help us with our deliberations. And with that, this panel is adjourned.
Thank you.